The High Court Family Division convened a special session which acted as a training and review meeting to evaluate the quarter one session dedicated to handling applications for extension of grants and probate. Justice John Edos, the head of the Family Division, described the special session as overwhelming, citing a heavy inflow of cases. He applauded the Judiciary Administration for responding promptly to the division's request for the additional support.
Because the number of registrations that came to the division were so many, I think it was unprecedented that as a division we're overwhelmed by what came in. And I want to take this opportunity to thank the administration for the intervention, because when we were overwhelmed, we made a call, and that call was heeded.
As we are all aware, the Succession Amendment Act 2022 fundamentally changed the landscape of the estate of administration in Uganda. Among other reforms, the law introduced a fixed validity period for grants of probate and letters of administration which were subject to renewal.
According to Justice John, the exercise which brought together judges from the various divisions enabled the Family Division to dispose of more than 1,000 cases. He noted that amendments to the Succession Act have prompted previously inactive administrators and executors to resume their responsibilities, strengthening compliance and accountability.
You are able to avail this estate to the beneficiaries for them to transact, for them to be able to get fees for the beneficiaries, for them to be able to mortgage and get money for commercial transactions. So in the last session, if I say that about 1,000 cases, over 1,000 cases, actually there were about 1,400 there. Of those cases were disposed of. You can see what was unlocked to the economy that people could now be able to deal with.
The resident judge of the Mbale High Court, Justice Kaseba York Charles, gave a detailed breakdown of Succession Amendment Act 2022. He explained the circumstances under which letters of administration expire and the requirements that constitute a valid will.
So the court has that discretion and the Administrator General to disregard a spouse if found unfit, and that is to the discretion of court on a number of reasons. Say she's a drunkard, she abandoned the home, and also where there are many arrangements of in Islamic marriages, if there are four.
He underscored the legal requirement for the written consent from all the beneficiaries or their guardians in the case of minors before an administrator or executor can dispose of the deceased property.
Is survived by only a customary heiress, and there is no surviving spouse, lineal descendant, dependent relatives. The property is divided equally amongst the persons nearest relatives. That one now you have to, there is a tree there in the Succession Act that can help you guide who is the nearest.
Stakeholders applauded the circuit for its strong performance, consistent output, and open-door approach to justice administration. They also renewed the dedication to strengthening justice delivery within the region.
Filing the original petition for grant of letters of administration or probate, and you find that they are in a fix. At the time of filing an inventory sale, they will not disclose that particular property.
My experience for the last few days is that we have to be very careful when we are handling these applications for extension.